Welcome, everybody, to this week's edition of Legalese with Doug Minor and Steven Palmieri. We come to you basically every other Thursday with relevant content related to the credit repair and the expert witness arena to help all of you out there who are watching figure out, some tools to kind of sharpen up the tools in your tool chest. And if you want to take your game to the next level and learn how to send cases out to attorneys and defend your work, this is the place to be. My co-host, Doug Minor, been in more suits than you can count on these fingers. We'll leave it there as a qualified expert witness. Doug Minor coming to us from, actually, you're coming from sunny California. I'm over here in Texas where we've got the freezing cold blackouts, man. How are you doing? I'm jealous. How are you doing today, sir?
Yeah, you have definitely reason to be jealous. It's a little too nice here, I think. But yeah, let's do this. Let's talk about credit and being an expert witness today.
Rock on, man. So we were kind of talking as we were getting ready for the show here a little bit. It's not just that you become qualified as an expert and then the attorneys, call you and hire you and it's all glory and fun. I mean, when you're out there, when you're testifying, you can sit out there on the bench and you kind of have to testify to put out your expert position on whatever the matter is. But then comes the cross-examination. And we were kind of talking a little bit about that. So let's talk a little bit about, what does it take to be able to prepare for your testimony, go up there and then being cross-examined by the other side. What's that like?
Right. All right. So there's a lot packed into what you just said. So let's I think, take it to the sort of beginning part of that. Like, you've been retained, you've done your report, and the case is going to trial. And so now I think one of the most important things is having an attorney that's hired you take the time with you to prepare you for the trial, right? Sort of pose those questions to you that they're trying to anticipate that the opposing side is going to question me on, right? And how am I going to answer those questions? It's kind of like what you were saying. You're defending your opinions, but you want to answer them in a very direct way, right? In the cross-examination part of it. So I think first and foremost, it's having an attorney willing and wanting to prepare you for a trial, or for that matter, a deposition. They're very similar as far as the questioning goes. And so that you can prepare. I forget who told me this or wherever I read it, but basically the premise was that you can prepare for 90, maybe even 95% of the questions that are going to come, but it's how you handle that other 5 or 10% that you didn't anticipate, how you handle those questions, right? That's where it really sort of separates you as far as being a really good expert to being an exceptional one.
So quick on your toes, foremost, I guess, quick on your toes. Yeah. You don't just kind of stare at them like, I wasn't expecting that, huh?
Right. Well, it's interesting. My kids, they see me when I'm working on cases every once in a while. They're sort of like, Dad, what are you doing? And they'll see a binder or they'll see me on the computer. And I try to explain to my kids, look, it's sort of like taking a final exam, whether it's history or calculus or whatever it is. But you don't know what the questions are all going to be. So you're just trying to figure out and study all the documents and be as prepared. I try to have as much information sort of marked that I think are pertinent to the opinions that I've put in my report, so that if there's some sort of graph or visual that I want someone to see, that I can get to that quickly and explain it very quickly. Because I think that's an important part to understand when you're testifying in a trial. Two parts to that. One, it could be just a bench trial and you're testifying in front of a judge, or if you're testifying in front of a jury and you have 12, 13 people sitting there and you're trying to it's like you're teaching a class to those people in the jury box, and sure, you want them to understand. And so, as what I do know is that everyone learns differently. And so whether they're visual, whether they're auditory, whether they're kinesthetic, you need to sort of speak to all of these sorts of learning abilities of the people in the box.
Some people learn by experiencing pain. I bet those are really good ones. So it's like, dear juror, imagine this was your credit report. I know you can't react to that because this could come back to haunt you, but imagine this was your credit report and they had this thing on there and it kept you, and these big bad companies kept on repeatedly not doing what they were supposed to. How would that affect you? So I don't expect you to respond to that, Doug. That's why you've got me over here. I can say these things, but you don't want to impeach yourself. Let's talk a little bit about that. So, I mean, when you are an expert, I guess obviously you got to kind of, hold a position. Let's talk about the bias versus the unbiased, right? I mean, everybody has some sort of a bias towards something, right? But I mean, you can't certainly go out there and be clearly saying that these big bad companies, are nefarious and all these kind of things, because that can come back, and no matter what industry you're in, right, and come back and bite you in the ass. And so, how does somebody in your position, how are you able to, do amazing shows like with a character like me and do other things and still, be able to feel comfortable, like, that, obviously you got your life to live and you've got things to do, but you kind of keep it within that box to where, how do you kind of separate like how you feel versus how you need to express what you feel?
Yeah, that's a really good, I like that. I've never had that question posed to me that way. I'll answer it this way. On the cases that I work on, whether I'm on the plaintiff side or I'm on the defense side, as far as you talk about being biased towards a company, that doesn't come into my consciousness. It's more about what happened, how it was reported, what's the impact. If it's XYZ Bank or it's Acme Data Furnisher, what did they do? What happened? How was it done? It's not, and sort of to your question, it can go both ways, right? The data furnisher or the big bank or whoever it is may have done everything correctly, right? Or in the complaint, what has been identified may not have impact on a plaintiff. So feelings aside, it's more factual. It's more, I think that's why it's probably easy for me. I don't have
I think that kind of leads us to further along in kind of this line of questioning and thought. So, obviously your job is, you're not a lawyer and you're not supposed to give a legal opinion. You're supposed to give an expert opinion, right? And so, part of like the FCRA, they can have negligent noncompliance, they can have willful noncompliance, and then you can kind of go beyond there if you're alleging like malice and things of that nature and stuff. So, like, are you ever on the stand, in your line of testimony, I guess, goes beyond the factual of whatever the facts of the credit reporting are, like, well, yeah, it's supposed to report this way based on my expert opinion, and it didn't, and they received 3 sets of disputes, and clearly they didn't fix it. But to where it goes to the next level, like, well, Doug, do you think that the credit bureaus were negligent or willful or malicious, which kind of leads into the remedies, that a consumer can seek out against them? Like, is that part of your testimony, or does it just really stay within the box of, well, the factual non-legal issue is what I'm going to testify about?
Yeah, so you're sort of right on that line. Keep in mind, so when in my reports, and you want to be careful not to give legal opinions as an expert. I'm not an attorney, and I don't profess to be one in any way, and so I don't make legal conclusions. There was a case, I forget his name, it escapes me right now, but there was an expert in this field, and he had in his report had, from my understanding, made some legal conclusions and was disqualified for that. So because of the way your group is and the pre-litigation side of it, I think maybe you bring up an interesting part where it might be difficult for some of the people watching or in this group. You have to give your opinion about it. You can't make a legal conclusion about it. So that's something to be very careful of, right?
Well, I think this line of conversation really goes hand in hand with the credit repair and disputing, because there's always a lot of conversation in our industry about, what can you do as a credit repair company, and where's the unlicensed practice of law, boundary. And I mean, my opinion is really, if we're doing dispute letters, we need to stick to the facts, which is understand how to read a credit report, which, Metro 2 is their industry standard. That's what I teach and share with folks. And the facts are, here's why it's wrong and here's why I assert that it's wrong. Not that, pursuant to the FCRA or this or that or whatever. I mean, you can certainly say that, you're supposed to report maximum possible accuracy information, and here's why it's not accurate. But my personal opinion is that you should never really ever have to quote a case law at all, ever in a credit repair. And I very rarely even quote the laws at all. Again, you want to stick to the facts, because that's what our jobs are, is to put them on notice. I mean, we have no authority to tell them that things are going wrong and that they broke the law or did this or did that. And, the better you can get at understanding how to read a credit report and figuring out what's accurate, what's inaccurate, I think the better you can get as a credit repair company to not have to rely on maybe kind of like some of these far out ideas of, like threatening the bureaus. But to kind of dial it back into what we're talking about here, I guess maybe from where you sit as an expert, obviously, like you said, it's a very fine line between giving expert opinion versus a legal opinion. And to your point, there was this expert somewhere along the line who gave what they determined to be a legal opinion, and they disqualified him for that case, which basically meant he was no longer able to be an expert. I think it was an important takeaway for those of us credit repair companies that are watching this right now. How do we master our craft, get better at disputing based on the facts, get confident and comfortable disputing based on the facts, to not have to kind of even really ask that question of, well, where does that unlicensed practice of law thing come? Because I mean, if you're out here sending out dispute letters, quoting case laws, I mean, you can argue the kind of the concepts behind case laws and say, well, it's inaccurate because you didn't do this and that or whatever. But I mean, that's a real dangerous game to play, especially if your documents end up going to an attorney, and then all those documents, are, well, I wouldn't say discoverable. I mean, because the bureaus have them or whatever, but, it's kind of like, well, did, Doug, the credit repair guy, I mean, did he write this letter where he basically accused us of being malicious and all this kind of crazy stuff? I mean, how can we take his dispute seriously when he's threatening us? So, I feel like there's some connection there. What would you say for those folks listening to kind of, I guess, learn from the expert side of things and get some takeaways to apply to the non-expert, which is us just operating as CROs, but to stick to the facts?
Right. So keep in mind, in some of the cases, a plaintiff may have employed a credit repair company at some point, right? Let's say I get a new case and they're sending over the documents and I see dispute narratives on credit reports from 2017, right? And we'll talk about this, but I have a questionnaire and I have a checklist of information I look for, and there's a whole bunch of stuff I go through in the beginning process before I get to that point. But you can see the dispute narrative on there and you say, okay, did you dispute this? And if so, how did you dispute this? And they're going to say, oh, I sent a letter. Oh, I did it on, I didn't even know I did it. Maybe I did it online, or I hired X company to do this for me.
Yeah.
Right. And then typically my follow-up question is, well, do you have a copy of those letters? I'd like to see what you disputed and how you disputed it, to see how, if the bureaus responded correctly, if the data furnisher responded correctly. And then in some cases, I'm given copies of the ACDV exchange and the forms filled out.
Sure.
So to the point of giving an opinion, right? It's, in my expert opinion, based upon what I know about the Metro 2 format and the eOscar system and how the ACDV exchange happens, and based upon this dispute letter, this reporting on this credit report is inaccurate.
That was perfect. Like, if anybody could bottle up, anything from the 1 hour long show that we're doing today, bottle it up and apply it to their credit repair business model, it would be that right there, because you so eloquently expressed how you're putting into words why they're wrong, but you're not saying, you broke the law and all this kind of stuff. And there's no reason why credit repair companies cannot take that exact same thing that you're going through right there, the same train of thought and logic, and write their dispute letters exactly like that, based on my understanding of Metro 2 and my understanding of Oscar and my understanding of your maximum possible accuracy requirement. This information still remains wrong after 3 sets of disputes, right? You're not like threatening these people or making any sort of legal demand. In fact, I think that's about as powerful a third or fourth round letter as you can get if it's going to end up getting in front of a judge at some point in time. It's plain English, and you're putting them on notice of the facts. For the third time in a row, you've seemingly ignored the issues at hand. And so one more time, please, we beg you, stop damaging my client, and please just fix or delete it.
Yeah.
So,
and Steven, the step further on that, sort of how it equates to doing expert witness work is, right, with the way I said that and all the documentation that's there, it supports my opinion about it, right? So
yeah.
had this been reported with X code or without the past due payment, their credit score would be much higher.
Right.
Because
yeah,
that sort of takes it into a whole nother area of the reports that you do in the testifying in, where you do a simulated score situation.
Yeah.
Right? You can show what the score is with the derogatory information, and you can show what the score would be without it.
Yeah, there's 2 ways you could take it. One is, dear credit bureau, my opinion is that you suck and here's why. The other one could be, again, I don't expect you to react. The other one could be, dear credit bureau, I'm just thoroughly confused because I can only imagine that you guys really want to do the right thing. And so I can't imagine that my last 4 letters resulted in this egregious, still continued wrong violation. I'm so confused, Mr. Credit Bureau. You can go either way on it, right? And the second way is the one that would look better if that document were to go in front of a judge, because now you're kind of seemingly giving them the benefit of the doubt. And obviously we don't really have firsthand knowledge of what happened to that letter from the time we lick the envelope and mail it out, right? We don't know like what they've done back there. All we can do is make, what do we call it? Make conclusions or whatever. All we can do is hypothesize that, well, why the hell do we have to send 4 sets of letters and they didn't fix it and they didn't delete it? But we really don't know. And that's where I think that's kind of a big thing is, if you're going to set up a paper trail, and a good paper trail that could be handed off to an attorney, and then somebody like you has to go in and potentially look at it, setting up the letters where they're really not emotional, I think is super important. Not emotional, but full of facts, right? Dear Credit Bureau, I'm just so confused at this point. I have no option but to send you another letter. Please help me understand, right?
Yeah.
And so and I think if we find ourselves doing that, as CROs, we're going to have a better ability to try to forge relationships with attorneys as well, and I know we've got some shows that we do here in this group, and we've got some attorneys that we do them with, and a lot of consumer protection attorneys really don't like credit repair companies. But if you could put yourself in a position as a CRO where you're taking that expert witness mindset, really, I think that's the takeaway, and applying that to the dispute letters that you're sending out, man, of course, then it leads to like my particular business model is I do everything on a power of attorney, even to the bureaus. And the way that I look at it is, well, why not? Why would I not want to put mine and my company's name on the document? Because I'm proud of it, because I'm like telling them exactly all up in their face why they're wrong, Yeah. And so if you can get into a position, and I'm not saying that everybody has to use a POA, but if you can get in a position where every document that you send out, you can honestly say, you know what, I would put my name on that document. And I think that really actually gets you within the spirit of CROA, because CROA kind of requires that you don't make false and misleading statements to the credit bureaus and things like that. But let's kind of dive in. So, have you been in cases where you've received, I guess probably we're in litigation at this point in time, maybe there's been some discovery or something, from your client, the consumer, and then where you receive, prior disputes from the credit bureaus, like they give them to you, disclose them in discovery or whatnot, and you get these dispute letters that are just kind of like hellacious looking. Like, has that ever happened to you? And if so, tell us about that.
Let's see. So as far as dispute letters go, yeah, I've seen many, some from credit repair organizations and some from the individuals themselves, right? And from what you were saying when you were talking about, I think it's a really cool point that taking the mindset of, as you said, being the expert, like an expert witness perspective. I think it's more about, I think it was 2 shows ago when John Watts, I remember him talking specifically about being as detailed as possible within the dispute letter, right? Being as specific and detailed as possible. I think if the CROs that are watching take that position, it will, if the case does get to litigation, I think that it just strengthens their case. And there's, let's say the stronger the case, the probability is that the more likely they're going to settle and want to settle quickly. Right?
Sure.
Like we've talked about in other shows, it's, maybe 5% of cases actually make it to a trial. But I think then it's when you're brought in as an expert, and I think I'm talking about myself specifically. One of the main reasons I'm brought into cases is to qualify or quantify the damages. What's the dollar amount? What is it worth? And I think that's what it's kind of, to answer that question, it's different for everybody, right? Everybody's socioeconomic status, everybody's way of using credit is different. Their life of credit is different from everybody else's. I use the analogy of it's like our fingerprint, right? It's unique to yourself. So as far as dispute letters, yes, I see them. I've seen many different types. Some are very simple, some are more detailed. Some are actually even written by the law firms that have retained me, where they were trying to help their plaintiff or their consumer in the case, right? So all different ways, it's.
Have you been in any cases as an expert where those prior dispute letters are produced and that has a negative impact on the case because maybe, what was sent out, it really is just kind of garbage, for lack of a better way of putting it out there?
I feel like there's usually more information or more documents that can support, or let's say let's assume that it's a very weak dispute letter. It's vague. It's not specific. It's this is wrong. There's wrong information. There's wrong information on my XYZ credit card account.
Sure.
It doesn't say, is it late payments? Is it the account? No, it doesn't say anything specific about it. So you can see those, but where an interesting thing is where that can play into a case that I would, let's say, be working on is the dispute narrative shows up. And at that same time or around that same time, there's documents that show that there was a 1003, a mortgage residential loan application filled out with such and such mortgage company. Well, that mortgage company ran their RMCR, their tri-merge report, and it shows a dispute. Well, for any of the mortgage people out there, they understand this. It's pretty simple. In the Fannie Mae guidelines, if there's a dispute narrative, usually the DU, desktop underwriter, the automated system is going to kick the loan out, right? Or you're going to have to explain it or what happened or what. So it becomes a bit of a hurdle to get over, and documents have to be supplied and letters have to be written just to appease an underwriter so that the loan can get approved, right? So it can cause problems. And let's say, assuming all of that goes on, and they lose being able to purchase the property that they wanted because of it, right? So now they've lost the property appreciation, they've lost the tax benefits of the interest deduction on their taxes. There's lots of different things that come into play when a dispute narrative shows up on a credit report, right? Even though it may seem simple, I think with my explanation, you can see that the implications of that happening can be much broader than just did it get removed or not.
That's a really interesting issue that we're talking about with the dispute notation. I think we may have touched on this on a previous show, but because the FCRA does require that disputed information be marked as disputed. But then, as you just said, well, now it's a Fannie Mae, which is a lender requirement, where they're like, oh, but no, if it shows disputed, too bad, so sad. And so, which kind of creates this really interesting scenario, because now you've got consumers that are having to call up the credit bureaus and like undisputed, basically. It's kind of like, I was just kind of playing with you the last 5 letters I sent to you, but now can you go ahead and just please remove that dispute notation, because I'm okay with you beating me up just the way that you are, and because I can get my mortgage. So so in that scenario, I mean, it would seem to me that would be more of a Fannie Mae type. Fannie Mae might be more responsible for the damages than the credit bureau, because if I'm the credit bureau, in all fairness, I would say exactly that. I would say, well, we're just doing what the FCRA said. We just we're reporting it as in dispute. We're not the lender. I mean, read the FCRA. It says we must mark it in dispute. So how do you handle that, and how do you differentiate the damages from the bureau's responsibility versus the Fannie Mae responsibility versus somebody else, when it's kind of a weird, a weird juxtaposition like that?
Right. So think about it this way. So, and correct me if I'm wrong, I'm getting the sense that you feel like the cases are against the bureaus. And not to say that I haven't been involved in cases where the bureaus are named in those cases, along with mortgage lenders and whoever else may be named in the case. Not all cases involve, and I guess I would say this way, the majority of the cases that I can think of don't involve the credit bureaus themselves.
Okay.
Right? So it could be a divorcing couple, right? So it's not about the bureau's situation, their involvement in that. As far as the dispute letter is concerned, I've never seen somebody, I guess I would say this way. I've never seen a plaintiff in a credit damages case going after Fannie Mae, right? Fannie Mae is just the guideline that the lenders are using. And anyone who knows mortgage lending knows that those are guidelines. They're not absolutely set in stone for every situation. And there may be add-ons, or there could be situations where certain lenders will accept a file even if it doesn't meet certain Fannie Mae guidelines, right? So it's not a question for me to say, oh, is it Fannie Mae's fault, or is it the credit bureau's fault, or is it the mortgage lender's fault? It's more about each individual case and who are the parties, and then how all that information interchanges and how it affects or doesn't affect a person that's suing a company.
So let's tie it back then to that. If you're suing the lender or the potential would-be lender for damages, in this case where maybe the loan did not go through because it was showing the notation of in dispute. If I understood kind of how we got into that was the hypothetical scenario. Then the lender is going to say, well, we're just using the Fannie Mae guidelines, and your client's the one that disputed it. I mean, so how can you tie the lender to damages for denying a loan when it shows in dispute, or am I not really kind of understanding where you were going with that conversation?
So I think I would say it this way. So let's say if the case involved a plaintiff against their existing mortgage lender who has the loan on their or mortgage on their existing home, the plaintiff then goes and applies to get a refinance on their mortgage with a different lender and is turned down because of a dispute narrative being on there, or some other information that their existing mortgage lender has reported to the bureaus that has caused the loan to be declined, let's say let's say that they have reported them 30, 60, or 90 days past due, which you may have documentation which proves that to be inaccurate, right? So the dispute is between the plaintiff and their existing mortgage lender who's reporting, let's say, the inaccurate information. The lender that they've tried to get approved with is turning it down by their guidelines. So there's no fault on where they're applying to, right? They're going to send out an adverse action notice, or in many cases, and this is, I don't know if this is going to go over well, but there are situations where if you've been in mortgage lending and you are originating a new mortgage and you say to a consumer, or the consumer says to you prior to running the credit report, yes, I'm having a problem with my existing lender, that's why I want to refinance, they've reported me 30, 60, or 90 days past due. As the loan originator, the loan officer taking that application, as a standard practice, you're going to say, well, if that's the case, we don't need to go any further with your loan because it's not going to be approved, right? And there's people out there who think that just because you don't have an actual denial on your loan by a mortgage lender, then you haven't applied. But I completely disagree with that. Doing mortgages for as long as I had, over 20 plus years of it, there's many times when a consumer may say something to you where you say, okay, well, if you ask them, well, have you ever filed for bankruptcy? And oh yeah, we did it last year. So immediately as a loan officer, you're going to know, well, it's 2 to 4 years, or could be longer, depending upon if it's 7, 11, 13. There's literally no reason to move forward with a loan application and spend all the money on running credit reports, having a processor process the file, having an opener originate escrow, title, all the things that go into a mortgage loan and all the costs associated with it. If you know something ahead of time, you're going to stop that process from going forward.
So that's really interesting. Okay, so if I'm hearing you, a consumer or a potential applicant, although they may not run through a formal decline, like a formal
Right.
origination application and decline process, they go to the lender, and the lender is like, oh, well, yeah, you're showing 30, 60, and 90, or you just told me you're 30, 60, and 90. I didn't even need to see your credit, and our guidelines require that you're currently current on your mortgage. So if it's true that you're 30, 60, 90 rolling, there's no need for you to apply. Good luck to you. And that's just a conversation. There is no formal credit application. There's no formal running you through the approval process to get the decline. So, so in that case, though, you're saying that you can still potentially tie that back to the lender that is reporting the inaccurate credit and make the case that, this person did not have to go through a formal, proper application and denial. But the fact that you're reporting this in that conversation prohibited the consumer from even wanting to move forward. And so therefore, even though it never really was an application, it kind of was an application and you're liable. Is that kind of what I'm hearing from you?
Yeah, it's as a standard practice, right? That scenario, it plays itself out. Let's say that, so one step further with this hypothetical, the loan officer says, no, I can't do the loan for you until you get the stuff worked out on your credit, right? Well, if they can't get it worked out and they're paying the mortgage, let's say they have a 5 or 6% interest rate on their existing mortgage and they can refinance it and get a 3% mortgage or less even. It could be $50, it could be $500 a month, right? Just depending upon the size of the loan. Well, until that inaccurate information is removed or suppressed from the credit report, they can't move forward with the mortgage application. So in my opinion, you don't necessarily have to have a full loan application filled out, declined, credit report run to know that they can't refinance with this information on there. I know they can't. Or even better, or even better yet, what I say a lot of times is, look, they're not going to get approved under conventional guidelines. They're not going to Fannie Mae, Freddie Mac under the, or if they were to get approved, they may have to do private money portfolio lending, and the interest rate might be 8 or 10%. And so there's no reason for them to refinance. It doesn't lower their payment.
Yeah.
So
Well, and so it's interesting where you're going with that, because, on the shows that we do with the attorneys here, a big thing of what the judges look for is damages. Even though like the FCRA, the negligent and willful noncompliance provisions of the FCRA do not require damages per se. It's basically, hey, if the bureaus or the furnishers did not comply, then you can seek negligent or willful noncompliance. That's why it's a noncompliance remedy, and it's not a damage remedy. It's like if you didn't comply with what the law says, they can hold you accountable. But fast forward a half a century of all the case laws, kind of where we are now, the judges like to see damages. And so if you have somebody, so kind of what I'm hearing from you is, you've been in cases where the consumer has been able to argue damages even though there wasn't a real, so the assertion of damages is not directly tied to a formal credit application, I guess is what I'm saying. And you've been able to make that argument, it seems like, numerous times. Well, judge, they had the intent to try to, use their credit. And before they could even use their credit, they were completely talked out of it. And so, yes, even though there really wasn't a credit application, please take our word for it that they wanted to give the credit application. So therefore there's damages. I mean, sounds like in those cases, there's kind of a more of a liberal interpretation, or an interpretation leaning more towards the consumer, based on the kind of what I'm hearing from there, versus some of the judges which may say, and this is just me speaking in the abstract, but, well, no, I mean, where's the damages, right? Show me the damages. Well, there was no credit application. Well, no. So, I mean, it seems like it's kind of a loosey-goosey area there, where, you don't necessarily have to have the formal credit application, but you're still able to make the case that there's damages. Is that pretty common, or is it maybe like a 50-50 toss-up, just depending upon, which judge you've got and which circuit you're in, and things like that?
I think that other documentation shows up, meaning there might be an email from the plaintiff to a loan officer at XYZ Bank. Hey, you did our loan 3 years ago. I'm looking to refinance. What do you think? So sometimes there's actual documentation of communications between the plaintiff and a loan officer, let's say.
Yeah.
Or there may have been, or it may have just happened in a phone conversation, right, with that. And there may be a written letter from the loan officer confirming that, yes, we did have this conversation. And yes, I agree that no, we could not get his loan approved based upon what he told me, right? And me as an expert in doing that for over 20 years, I can say that those conversations are a standard way of doing business. That's what loan officers are going to do. That's typical standard practices, is what's going to happen in that situation. So yeah, you don't necessarily have to have the formal decline on a mortgage loan to include it in a damages calculation.
So let's dial this back to our audience here. Credit repair companies, credit repair business owners. Just like earlier, we were kind of talking about, take that expert mindset when you're doing the dispute letters, and don't accuse them of all these, legal things, but I mean, put them on notice of why they're wrong. And so to this effect, if you do an interview with your client when you first hire them, and you find out really legitimately what the story is and why they're being damaged, that's hugely powerful. I mean, it may not necessarily, especially with the bureaus, it may not really necessarily improve your deletion ratio. But, again, if on the credit repair side, you figure you go through an average 4-letter life cycle for your clients, because really we don't want to send them to attorneys. We just want to get the deletions, right? But, you go from letter 1 to then you tighten it up to letter 2, and then you tighten it up to letter 3. And, I like to send my subsequent letters, also send versions of the letters to the furnishers, let them know how they've screwed up and what's wrong and things like that. And so if you've got a story, again, I don't believe this is going to have much of an impact on the bureau side, but if you are disputing with the furnishers, and especially if you're using a power of attorney like I do, and you're putting like, and they receive the furnishers receive this letter like on your power of attorney, Doug Minor, Doug Minor, credit repair genius, guru, Inc. It doesn't matter what the company is called. They're going to judge you based on the contents of your letter, right? And they're going to first of all know, oh, well, look, this guy's got a notarized power of attorney at Doug Minor Inc. And let me read what he says. And then, you're writing in there, well, dear furnisher, first let me just, inform you that, the consumer hired me, and here's how I believe they're being negatively impacted or damaged. They are trying to get this mortgage, they're trying to do this, they're trying to do that, and they can't. We believe it has something to do with the reporting, which as of yet has failed to been deleted or fixed. That story, I think, can definitely help you on the furniture side, and especially if, and again, not even necessarily like for all the furnishers on your first round, but if you're able to send subsequent rounds or escalate them up to their compliance officers or to an executive, maybe even make a phone call over there. I mean, if you have a real legitimate story, I think, and I had a call with one of the guys in my training group just the other day, and you're not going to win all the time, right? I mean, a lot of these big box organizations, these lenders, yeah, it's luck of the draw, even if you've got a decent case. But I mean, for your average furnisher, that's not a big giant, huge freaking enterprise. I mean, if you can reach out to them and you can put them on notice of a legitimate reason, number one, why it's wrong, and number two, how the consumer is being damaged, they would really be foolish to ignore that. And so I think from there, that's just, another way we can kind of take something away from, how you conduct your business as an expert witness, tie that back to what we do as credit repair companies. And then, the natural consequence or effect of that is that we are really getting closer to becoming experts ourselves, because we're doing everything that you would do as an expert witness. We're not necessarily sitting there and defending a court case, but we're defending the client, right? I mean, but we're defending our position that they've hired us to do. And so I know you did credit repair, kind of before you morphed into becoming an expert. I mean, how do you feel about, all that, and, being able to use the story with the furnishers and, act as if you're an expert, and to try to reduce the need as a credit repair company to actually send your clients to attorneys?
I think, listening to that, I think it's great to, like you said, your first sort of business at hand is trying to correct the credit report for these clients, right? You hear the story, and if it's inaccurate, you want to correct it, and hopefully, it's either deleted or corrected, and it helps your client, right? But I think if it's at more at the forefront of your mind that, hey, if I do this all correctly, that this will help these people or person to file a lawsuit, and hopefully have the information corrected or deleted, and receive some sort of compensation for what they've been through, right? So I think it's a good idea to think more, at least for some of the credit repair organizations that are watching this. I think it's a good idea to do what we're talking about, and draft the letters in the way that you're talking about, or like John Watts talked about, and be specific. And then if you're unsuccessful in getting it worked out for them, having the right attorney to refer them to help them go forward with it. I think a lot, I don't have any factual data on this, right? Okay, so I'm not gonna say that this is any, but I would venture to guess, I'm gonna use the word guess specifically, that there is a fair amount of people out there where things have happened to them on their credit, but they can't afford to file a lawsuit, right? Mm-hmm. Hiring attorneys and drafting motions and going forward, it can cost a lot of money for someone to litigate one of these cases. And so I don't know that there's any data that would show how many of these types of cases are out there but never are heard or never are filed as lawsuits. But with all that said, having an attorney that you can speak to, or that would take on these types of cases, like a John Water, Cardoza, is a great way to help your client or help that person get back on their feet or get their credit fixed back up because of no fault
Yeah.
of their own.
Well, that is one of the awesome things about, kind of what we've got going on here with the pre-lit community, is that we've got so many folks in here. I mean, we've got you in here and you're open and approachable. You're a qualified expert and we've got attorneys. I mean, and I really believe that you can be an amazing credit repair person, but if you don't have, strong supporting legal people and attorneys behind you, you just haven't really fulfilled the potential of the business model. I mean, there's always going to be those cases where there's going to be those tough nuts to crack, as they say, and if you don't have a good attorney to go to, it's going to be tough. On the flip side, if you do have a good attorney to go to, it enables you to, start to build up more leverage with some of the furnishers and the collectors. If you start to get a little bit of a track record, because, if you reach out to them, again, the value of using the power of attorney and your letterhead. I mean, if you're sending stuff to these furnishers from your company, they're going to know who you are. And I personally believe that is invaluable. I mean, why, again, would I want to put a master document together and then send it out as if it came from the consumer when I'm so proud of the letter? I'm going to send it on my letterhead. That way these organizations know who I am, and if you call them and reach out to them and record a couple phone calls with their people and file enough complaints and even CFPB complaints, I mean, I think there's definitely some value in our business model that you can get from, I guess, for lack of a better way of putting it, the relationship portion of the dispute letters, right? They know that it's coming from you and they know, oh, he's, this is, Doug Minor, he's got this attorney behind him. Let's just go ahead and acquiesce. Let's go ahead and delete it. Let's not fight him, because they get all these letters all the time that appear as though they come from the consumer. And a lot of these letters, I'm sure, are just kind of, gibberish. And they, I'm sure, do get really good letters as well. But the amount of times that these bureaus, number one, get sued, or not the bureaus, but the furnishers get sued, is not nearly a lot when compared to the number of disputes. But I think even less prevalent is the amount of people that actually reach out to them, legitimately on a power of attorney and say, dear so-and-so, this is me, this is Steven, and I've got a POA here, and I wanted to just, kind of let you know that I'm right here letting you know. So what are we going to do about it, right? And I mean, especially if you record those phone calls, or even if you send them certified letters or whatever, I mean, even if they don't do the right thing, I mean, they've got to be foolish, because now you've got a really well-built evidence pattern right there. I mean, look, I even tried calling them, or I sent a certified letter to specifically this individual, and the return receipt got sent back as delivered, and they still ignored it. And so I think, I think there's a lot of value in acting as if you're an expert, to kind of tie it back to what we're talking about here. And, to hopefully help folks be able to get better results, before you need to escalate up to the attorney side of things. But, as we're kind of getting towards the final stretch here of the show, let's kind of bring it back to where we started, which is, okay, you're on the stand, you are providing your testimony, you're giving your expert opinion, and it's going along great. And all of a sudden it comes at cross-examination. And so, I think there may be some folks, credit repair companies, some folks watching here who are like, this is really exciting and this sounds awesome, and I'd like to maybe at some point be an expert witness, but man, I'm just kind of like, I'm kind of nervous or kind of scared. I don't really want to be up on the stand or whatever. I mean, so, tell us what it's like. I mean, have you ever been like really beat up hard, by the other side, where it kind of makes you want to, cry like a little baby? Or, I mean, is it usually pretty professional, even on the cross-examination side of things?
Wow, that's a my mind just flooded with all different situations. It's a fantastic question.
I guess at least you're not sucking your thumb right now. You're like, well, there was this one time they made me cry right there, huh?
No. I have lots and lots of stories about being on the stand and different situations. Let I'll run through. Let me just give you a couple quickly. One of the first cases I testified on, it was in federal court. It was an FCRA case, and I was being questioned by opposing counsel. And interesting, the first time the attorney asked me the question, he was sitting down at his table, just very calmly asked me the question, and I answered it. As attorneys do, and as good attorneys do, they change a little bit about the wording in a question. It's very similar to what they just asked you, but you have to actively listen to what those changes are, because you don't want to be just saying the same thing over and over again. And to make this story shorter, this attorney asked me a similar question about 5 times, maybe 6 times. And by the sixth or seventh time, he was almost nose to nose to me, literally almost yelling at me with a super red face. He was getting so aggravated with the way I was answering his questions. And I believe it was after the 7th time he asked me, and he was so loud, he was just, face was beet red, and he's yelling at me. And I looked at the judge, and I was like, kind of like, really, are you gonna let this go on? Like, and finally the judge says, said something to him, okay, enough, move on, ask another question, right? So that was kind of an extreme. It doesn't typically get like that. It really, that's just one that sticks out in my mind, just where it got so out of hand, I guess. Other times it can, judges typically, in my experience, keep the questioning portion, whether it's how direct or how aggressive it is, the judges seem to keep a level of professionalism and decorum in a courtroom. So that's why I like to say what I enjoy most about being an expert witness is testifying on the stand, because it's your chance to teach and explain and go into detail. And judges, in my experience, tend to give you more latitude to answer certain questions. Or I've had in numerous cases actually where judges have leaned over and asked me specific questions, let's say to where nobody else in the whole courtroom could hear it. So the aggressiveness and the questioning, you do have to be prepared. Those types of things could happen. One other case kind of pops in my head. It was one of the first cases, and I remember being on the stand, and the attorneys were representing one of the, let's say, big 5 banks that we're all very aware of here in the United States. And at their table, I think there were 2 or 3 people sitting at the table with laptops, feeding questions to the attorney asking me questions. We talked about this in an earlier interview where they asked me about
my earpiece. Hold on, I can't hear the next question. Give me a second, Your Honor. Judge.
Yeah.
Hold on. My handler. I can't hear my handler here real quick.
Right.
So.
So yeah, I think you do have to be prepared for. It could feel intense, and to your point, do you feel nervous or do you feel afraid? I think that's everybody's, how they handle those kinds of situations is different, right?
Yeah.
And I think what serves me well is, I think, my professional athletic career, being in intense situations, racing at the world championships against the best guys in the world. I guess I thrive, or I do extremely well under extreme stress. I'm okay.
Sure.
I'm used to paddling out in 20-foot waves. Where
Now,
most people.
what about if they try to box you into yes and no answers, and you really don't want to answer those? Let's talk about how do you wiggle out of the yes? Just yes or no, Doug, please. Yes or no. Answer the question. How do you how do you wiggle out of those while under oath?
Right. I think, look, sometimes yes or no isn't the answer. Right?
Did I stutter? I said yes or no, Doug, please. Yes or no. Judge, hold him in contempt of court, please.
Right. Those situations happen. And I think specifically in credit, right? Like you hear us, it depends. Right? It depends. Did they do this or was this? There's all of these factors that go into if they're trying to pin you down on a yes or no answer, but the answer isn't yes or no. It depends. It depends on this. It could be yes, or if it's this, it could be no. Right? I'm not. So just because you want me to say yes or no doesn't mean that I'm gonna say yes or no.
Okay, so they can't really box you in like that then. I mean, you've got some latitude to kind of justify why you're not answering the question. Because I mean, they can say, well, you didn't respond, right? You didn't answer the question.
Sure, they could say non-responsive or didn't, but those types of things can happen, and it's just a matter of how the question was asked, and do you agree or not agree, or do you think you can answer it yes or no? Right. I think the boxing in part, though, sort of one of the examples that people not knowing about experts is where they'll try to box you in and they'll say something along the lines of, how many credit repair clients have you had success with? Right. It's kind of a fairly vague question. And I don't know that any credit repair organization is going to know specifically off the top of their head how many different individuals or credit reports or trade lines that they've fixed. And the answer might be somewhere, I'm just going to pick out the numbers out of my head. It could be, 100 to 500. Well, is it more than 500? Well, maybe it's 600. Right? So they're going to, when you are questioned and you're put into these numbers or in these boxes situations, what I learned was that you need to keep that box as open as you feel is safe, and also do not deviate from it. If you're not sure, you shouldn't put yourself out there. Where I remember I was questioned one time about a situation, and I said, well, it could be as little as 3 times, or it could be as many as 30 times. And the follow-up question was, well, was it ever more than 3? And as soon as the attorney asked me the second question, I immediately recognized, oh, he's going to try to box me in. And so my answer stayed the same. It's been between 3 and 30. Well, you sure it's not? No, it's been between 3 and 30. That's what I'm confident with. It's between 3 and 30, right? So there, look, it could I have changed my answer? Possibly, but at that moment in time, in my recollection, I wanted to keep myself in a confident, safe, honest spot, right? Yeah. That's it. So yeah, being boxed in is sort of a common thing that attorneys will do in their questioning, and you have to be prepared to answer those questions. And keep yourself within a safe, reasonable box. That's all.
Well, hard to believe it's been pretty much an hour already, man. These shows just go by. Hopefully for our fans. I know Warren commented to man up and don't be scared when we were talking about if you get examined. And so I'd love to see Warren become an expert and sit up there. I know he put a hurting back on some folks. But for those folks who are watching, how can they get in touch with you? I mean, and if they want to either get coached by you, get trained by you for expert, or just have any questions, what's the best way for folks to well, I guess first let's say, so you do kind of have a little let's talk about how you can help folks. So give yourself a little plug. Give yourself a little plug here at dougminor.com.
Right. So you can go to dougminor.com, or you can go to doug@dougminor and email me. As far as questioning, if you've been asked to be an expert or you're interested in doing it, I do teach individuals how to be expert witnesses and go through the processes and so forth. And then, as far as using me, or I'm used a lot, or I'm asked to help people with cases even before they filed litigation. Like, hey, what do you think about this? And I'll do that. I just charge a fee for my time to sort of look over the documents and give them my opinion about where the strengths or weaknesses are in the case, or things that they may need to gather, or things that they can do. So
And if somebody's a CRO and they're really serious about wanting to take it up to where they become an expert witness, certainly you can work with those folks as well and help them
yeah,
with that.
absolutely. Yeah,
Yeah.
absolutely.
Yeah.
I've done it for but as we talked about off the air before we started, I've actually helped people in other industries outside of credit repair to become expert witnesses. So it's what I do isn't just credit repair organization specific, but that tends to be the most because that's the space I'm in. That's all.
Awesome. Awesome. Well, as usual,
Yeah.
I appreciate you doing the show with me, and it's always a blast. And obviously, for those of you guys watching, if you want to learn more about pre-litigation disputing, Metro 2, power of attorneys, all that good stuff, we do have the pre-litigation training course, which, Doug, I've got to say, you're actually a member of. A man of your caliber is, hey, never stop learning, right? I learned from you, you learn from me. We do have the training course, $99 a month, and you get a 30-day free trial. So feel free to reach out to me or go to stevenpalmieri.com, and we've got some more information on it there. So that being said, guys, we appreciate all of you for being here, and we will see you in 2 weeks on the next show. You guys take care.
Wow. Thank you.